Hey out there, legal warriors, if I told you there was a set of classes you could do to help get your criminal case dismissed, at least if you were charged with a crime of domestic violence, would you be interested in that? Would you want to hear about how something like that works? If so, stay tuned because this is the video for you. My name is Attorney Lance Fryrear, and I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes for more than 20 years, and I'm putting out these videos to help educate the public. So if you like this video, if you find it useful, please like and please subscribe. More people will get the help they need, and that's why I'm doing this. So I'm just going to jump right into it. There are certain times when you can do classes to help your attorney get an offer out of the prosecutor to dismiss your case. And there's a newer invention over the last year or two that I want to cover here. It's called DVMRT, Domestic Violence Moral Recognition Therapy. And that's a set of classes that has become popular for courts and prosecutors to have defendants do in non-felony domestic violence cases to improve their position, and sometimes to get some type of SOC offer, stipulated order of continuance, to get a case dismissed. And I've got other videos on SOCs. Make sure to look those up if you're not sure what that is. But I want to cover sort of what the old way is and what the problems were with the old way and why we don't have those same problems with the new way, this DVMRT. I'm going to cover how we used to do things with traditional domestic violence treatment, what the downsides were, how those are sort of not present for DVMRT, what to expect in DVMRT classes, how much they might cost, and how your attorney is going to use them, hopefully, to help not only better you, but get you a better result in your case. So what is the old way? Well, in a non-felony domestic violence case, typically assault 4 DV, many times the prosecutor in court would order or ask that the defendant go get a DV, domestic violence evaluation. So you'd go to a treatment provider and they would charge a lot of money, maybe $500, maybe $800, for you to answer a bunch of questions. And from my opinion, from doing this for the 15 years that was popular, the results always came out the same. It said, you're an abuser and you need 12 months of treatment. You need 52 weeks of very expensive treatment, fork over $6,000 or $8,000, and go to classes every week. And if you don't do everything right, and if you don't say everything we want you to say right, and if you don't totally eat dirt, and if you dare to say anything that it wasn't totally your fault, the treatment provider is going to say, you're out of compliance, you're not accepting responsibility, here's your non-compliant report to the court throws you in jail. That is a little bit about how it felt. Now, there are good agencies where we'd send our clients that wouldn't act like that, but many, many agencies, in my opinion, had someone running the classes that if a person who might be doing the classes to help their case and might not totally feel it was their fault, and it might not have totally been their fault from being there, believe it or not, I'm not victim blaming at all, but sometimes the police do get it wrong. That person, if they piped up, they would be found out of compliance often, and then they could go to jail. And there was no way to fight about it, right? It was subjective. Whether or not someone progressed in treatment was subjective. I always would say there was no urine test for rage and anger and control. In drug and alcohol treatment, if you take a UA and there's nothing in the urine, you're successful. Well, there was no way to do that I've ever seen in subjective DV treatment that the court enforces. It still could be a good thing, right? I'm not against it, but it was bad in that it put the client's freedom up to some random person who ran the classes that we knew nothing about and we couldn't even fight about, right? The court was never going to be in a position to substitute its judgment with how busy it is for that of the professional. So it was hard. I mean, I've had cases where people had to flee the state because of problems, and then the treatment provider got fired and came back and everything was fine. So the nightmares are real. And so happily, when DVMRT came around, that's an objective type of situation. You don't have to get evaluated to get into these classes. These classes were primarily run by probation officers who were teaching a standardized curriculum from a book, right? And there's 24 weeks of classes. And the other good news is they're cheap. Most of them are about $200 for 6 months. I've seen a really good set we send people to is $400 for 6 months just for the convenience. But you could join at any time. You didn't have to wait, right? Someone could be on lesson 5 and you could be on lesson 1. And you read your lesson and then you do the lesson, and then you present it to the group, and then the group talks about it, right? And we all, have something in common in the group, and we're at different points in our life, and we can be a little more open and honest, and still, take responsibility for our part in how we need to change things. But you're not going to get violated because there's no perfect right thing you need to say, like there was in some traditional treatment. So DVMRT is working out, in my opinion, because you don't have to get an eval, it's inexpensive, and it's objective. So you really can, be accepted and gain something from doing the DVMRT. So when might you want to do DVMRT? Well, when your attorney tells you to, number one. And also why you might want to do it is, hey, it might help get your no contact order dropped faster if the alleged victim wants it dropped, right? It's going to help you feel better. It's probably going to help you be better if you put some effort into it, right? Don't just, not put effort into it. If you're going to spend your time and some of your money on it, do your best. Do your best to learn what you can and to share your knowledge with other people in the group that might not have as much experience as you, right? So, it's a win-win, I think. So how might your attorney use it, right? Well, your attorney may use it to try to, again, move to drop that order, and also try to negotiate with the prosecutor. As I said, many prosecutors have the ability, if they want, to offer you some type of a resolution that could lead to a dismissal. And that's usually called an SOC, and many places will really put some heavy weight into doing DVMRT classes and offering an SOC. Even some felony prosecutors, while there aren't SOCs for felonies, may strongly consider the fact that a defendant is taking responsibility and learning and doing classes on their own prior to being ordered to. And sometimes that can lead to a felony getting reduced to a non-felony, which could totally change your life, right, without having to go to a trial. So what are some objections that I hear? Well, hey, if I do DVMRT, I'm admitting I'm guilty. No, that's not true. Right? I have a whole video about doing classes is not an admission of guilt. A prosecutor is not even allowed to use the fact you're doing classes to prove something. They can't say, well, Miss X is doing these classes, therefore she knows she's guilty. No, not admissible, not a solid argument. The evidence rules forbid that. So, and they're not thinking about it that way anyway. The prosecutor already thinks everybody's guilty, right? So, as far as when isn't it always useful? Well, some counties, some felony prosecutors really don't care much about that, right? So ask your attorney. I think felony DV in King County probably cares about that more than in Snohomish County or maybe Pierce County. It's just it changes as prosecutors change. But in misdemeanor land, I think it's pretty universally recognized as one of the gold standards right now about what a defendant can do to actually help improve their position. So it's this win-win. It doesn't cost a lot. It can help improve the case's position and also help get the defendant thinking about, whatever happened in a new way, right? What could they have done differently to not have been in this situation and caused the harm that they're alleged to have caused, to the person that hopefully they cared about. Because in a domestic violence case involves family or household members, so it's not a stranger typically. So DVMRT, I think I don't think it's dangerous to do. They're not going to hold it against you. If you end up not needing to do it, you can stop it if you want, or you can even continue if your case gets dismissed early, or if for some reason the prosecutor doesn't care. So I hope you find this helpful. As you can tell, I think it's a positive tool, and I hope this answered some of the questions you might have. So if you found it useful, please like and please subscribe. And even more importantly, if you have a criminal problem, feel free to reach out to my firm. We've been doing this for more than 20 years. We probably do more domestic violence cases than anyone in the state. We take a therapeutic approach. We want to leave our clients better than when we found them, and we want to make the most out of the crisis. So give us a call. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.